Do you recognize this document, Mr. Miller?
Yep.
What is it?
It's the Princess Bead box. Your Honor, motion to move to admit this into evidence as Defense Exhibit 1.
Objection, I believe that you previously ruled to keep this out.
Yeah, you guys made a motion to keep it out beforehand, and that was overruled. So no, that was already
If I
sustained.
may make an offer of proof, Your Honor.
No, we already earlier ruled that that wasn't coming in because this is a negligence per se case. So why would it come in now?
Your Honor, under Flounder versus Minnesota Refining, the defense is allowed to present an affirmative defense, a comparative affirmative defense. Unlike some other jurisdictions, Midland's law expressly recognizes and permits a defendant to raise an affirmative defense of comparative fault in both strict liability and negligence per se.
Now, didn't we just?
And this document will go to Mr. Miller and Miss Davis's awareness, the effect of.
But didn't we already litigate this earlier?
Yes, Your Honor, I believe you ruled to keep it out.
Wasn't it Hamilton versus Dr. Fu's Home Gyms? That was the relevant
Case law.
case law that was given to me, and it says the focus in a negligence per se action is narrowly confined to whether the defendant violated a duty imposed by statute or regulation, and whether that violation resulted in the harm that the statute or regulation was designed to protect. As a result, a great deal of evidence that would entirely be admissible in a traditional action based on negligence, recklessness, or strict liability is simply inadmissible in an action based on negligence per se.
Yes, Your Honor, but in Flounder versus Minnesota Refining, it says our decisions in Hamilton versus Dr. Fu's Home Gym and Brendan versus Munson are not intended to exclude evidence offered to prove or rebut affirmative defenses, including comparative fault. And this document will go to show the effect that the packaging had on Miss Davis and Mr. Miller.
Wait, I'm confused. During the plaintiff's case, who moved to exclude this evidence?
We did.
You did or they did?
We did.
You did. All right. And the basis of your exclusion was?
That under Dr. Fu's Home Gym, we focus on negligence per se case, like you said, whether, strictly limited to whether the defendant had been violated or not.
Right. So I'm going to stick with that ruling. I'm going to go with the Hamilton versus Dr. Fu's earlier ruling I had this morning that, well, for this case law that's stated right there, the focus of this is narrowly confined. So I'm going to sustain the objection.
May I retrieve the document, Your Honor?
Yes.
Thank you.
5 cents.
Have you seen the Princess Beads before?
Yeah, I have.
And have you seen the packaging before?
Yep, yep.
Did you notice any warnings on the box?
I did. I noticed 5, I think.
Objection, Your Honor, I believe they're referring to warning labels that you recently ruled not be admitted to.
Yeah, I ruled that, I mean, according to Hamilton, which we got into earlier, that, the evidence about the defendant's subjective awareness of the risk posed by a particular product, its reasons or lack for proceeding in the way it did, and its consideration or failure to consider alternatives, all of these things are out in the negligence per se action.
Your Honor, Mr. Miller is an agent of the plaintiff and not the defendant in this case. And this is going to show Mr. Miller's awareness of the risks associated with the object.
Well, I wouldn't call Mr. Miller an agent of the plaintiff, but he's certainly not the defendant. That's true.
Under Stipulation 8 in Special Instructions, it says that Mr. Miller is, in fact, an agent of the plaintiff.
Counselor?
Yes, this is true.
Okay, then under that, I've got to let it come in now, because it's not being used against the defendant, right? It's being used against.
Well, I think the stipulation states that Mr. Miller was agent plaintiff only on August 8, 2005, not that.
Yeah,
He's always been an agent of plaintiff, so.
Right, but what we're talking about here, at least under Hamilton, is the defendant's, how the defendant is acting, right?
If this applies to Mr. Miller's subjective awareness of labels,
Okay, and is that what it's going to go to?
Yes.
Okay, proceed. Overrule the objection. Proceed.
Could you describe what was on the packaging of the box, please?
Well, there were these little girls, I don't know, maybe young women, who were playing with some stuff on the front of the box.
Was there anything else in the box?
Yeah, there's a number, it's a 9+. So I took this to mean that it's intended for children 9+. And there were also warnings on the bottom.
And could you describe for me the first time that Joey Davis saw the beads?
Yeah, it was weird. So it was at his sister Hillary's birthday, and like as soon as she opened the box, it was like his eyes just like lit up, like he was on something, and he squealed in delight and reached out towards the beads.
Now, after this birthday party, where were the princess beads kept?
They were kept. Well, at first they were just kept all around the house, but then we decided to store them on the coffee table in the living room.
Was this table within Joey's reach?
Yeah, like it was like I actually bumped my shin against it all the time. It was a really low coffee table.
Was there any other instance that Joey Davis showed any interest in the beads?
Yeah, there was this one time when we were doing what we call drawing time, and that's really, I take a nap and Joey draws. And but when I woke up, I saw that Joey was sort of looking over at the beads and was drawing little circles that were colorful, and to me they looked like princess.
Now, did you think about the warning labels when you saw Joey making the drawing?
Did I think about the warning label? No, I didn't.
Did you think to move the beads away?
No.
Mr. Miller, did you ever see Joey Davis put the beads in his mouth?
Well, as I said, he really put everything in his mouth. So yeah, I did see him put the beads in his mouth once.
And were you concerned at this point?
No.
Did you think about the label that you had seen that said, warning, choking hazard, not for consumption, may be toxic if swallowed?
No.
Did you clean the beads up?
I don't clean.
Did you take Joey away from the beads?
No.
Did you move the beads to a place out of Joey's reach?
No.
Did you ask Hillary to move the beads?
Actually, Hillary and I, we don't really get along, so I didn't really talk to her very much.
Mr. Miller, did you do anything at all to prevent Joey from being near the beads?
No.
Now let's move to August 8th, 2009. How did that day start?
Well, I woke up at 7, went to the gym, tanned, did my laundry, my usual GTL, and then I arrived at the Davis household at around 10.
Were the princess beads there that day?
Yeah, they were in their usual place.
Did anything unusual happen that day?
You're not referring to the incident at the tanning salon? No. No, so Andy left at like around 11, and then at noon, Joey got hungry. And I don't really like to cook, but whatever, I did it. I actually do learn how to cook, well, whatever. And then I went to make him some macaroni and cheese. And when I got back, she was just lying on the floor like she was passed out or something.
Now, when you went to make the mac and cheese, could you see Joey?
No, I was focusing on the mac and cheese.
And could you describe exactly what you found when you came back?
Yeah, well, as I said, he was lying. He looked like he'd had a really rough night. He was lying sort of on his side, which actually that's how you are supposed to lie after you've had a rough night. So that was good. But there was also, he didn't look good. So I decided to take him to the hospital.
Now, Mr. Miller, who was responsible for Joey Davis on August 8th, 2009?
Responsible. I don't like responsibilities, but I guess you could say that I was.
And did Andy Davis talk to you at all that day?
She did.
And did she say anything at all?
Yeah, she really tore into me at the hospital, and she said, you were supposed to be doing your job, blah, blah, blah. If you had been doing your job, blah, blah, blah. None of this would have happened.
Objection, Your Honor. I believe this statement is not prejudicial and corruptive. I believe that inflames passions in the jury since it is a statement that was made when Miss Davis was under extreme anguish from testifying found out that her son had recently died. I don't think it's at all representative of Miss Davis' truth.
You can argue that in closing, or you can cross-examine on that all statement was made. Go ahead.